To this story, the Office of the Chief Justice says it's investigating reports of irregularities in an IT tender worth more than 200 million rand. Three officials alleged to have helped arrange the tender. They've since resigned and will reportedly receive almost 70 million rand from the deal. To discuss this further now, we're joined by Accountability Now's Director, Mr. Paul Hoffman. Mr. Hoffman, thank you very much for your time. You know, this particular case could have fallen off the radar given all the scandals that we're currently dealing with. But it was very important that it be tackled nevertheless because it's equally concerning. You've got three former senior officials who sat on a bid adjudication committee. They resign to then go and be awarded a subcontract with Reuters, which is the successful bidder. What do you make of this story?
Well, the only welcome news in the story is that the Office of the Chief Justice is busy looking into the matter, which is welcome in the sense that the proper administration of public money has been abused for too long in South Africa. And when it reaches the Office of the Chief Justice, then you know that there is a serious problem. The investigations that the Office of the Chief Justice will commence this week, I presume, will take them in the direction of the principles that apply to the procurement of goods and services by the state using public money. Because this case line's IT solution to the problems of administration in the court is a procurement using the people's money. And in order to be valid, it needs to comply with the 5 criteria that have been set down by the Constitution itself. 5 are that the procurement of case lines had to be done in a way that is fair, equitable, competitively priced, cost-effective, and transparent. And if it is apparent from a preliminary investigation by the OCJ of what went on in the deal, that irregularities occurred, it can invoke the provisions of the Public Finance Management Act, which give the power to the Auditor General to investigate irregularities in procurements. And it is quite possible in this case that it will be seen that the deal that was done by the 3 former officials was neither fair nor equitable nor competitive or cost effective. If the deal was put together in such a way that they would get a nice bonsella out of it because they'd favored the winning bidder, then the deal is irregular and it should be set aside, and the money that they would get out of the deal should be returned. The need for a subcontractor, if indeed there is a need for a subcontractor, needs to be put out to a process that is compliant with those 5 criteria.
Mr. Hoffman, there seems to be a problem here, though. If perhaps in the instance of Reuters, they were in fact the qualifying bidder, they deserved it, but in this instance, what happened before, or which was not within their purview, now seeks to disadvantage them. What happens in that respect? Because we could have where bidders are bullied. Because from the article that we read from the Sunday Times, it seems that Reuters actually was offered the contract, and then while it was now busy with its recruitment process, getting locals that it wanted to recruit, it was then informed that now you would need to relinquish 30% of the profit you are to make in this contract to a local subcontractor. So even the procedure that took place there, from the onset, it should have been placed as part of the requirements in the RFP. It wasn't there. So then it's inserted later on that you'll relinquish 30%. Is that not bullying? And it's not to say in this instance because we don't have all the facts, but nevertheless, are we not seeing cases like these taking place in many instances where you have companies who bid for a particular contract being bullied at times by those that sit on these bid adjudication committees?
Yes, that's what the Americans call bait and switch. So you bait the tenderers to make an offer to procure the goods and services required, and then you change the rules of the game after they have successfully bid. Now, here we don't quite know what the 70 million rand is all about. Is it a handshake to the three officials that saw to it that Thomson Reuters was a successful bidder in the main contract, or is it a revision of the main contract in a manner that is irregular? You see, if you want to change the rules of the game at half-time or midstream, then you should start again. They should have said, sorry, Reuters, we've changed our minds about the way we're going to do this thing. We'll allow you to bid competitively with everybody else, but a third of the contract must be given to a local partner.
They offered a response to that, Mr. Hoffman. They offered a response and said they didn't have to re-advertise because Reuters was the only one that had the license. So there was no need for advertising. And what is equally concerning is that the gentleman, one who's representing the three that used to work now for the OCJ, Natim Ngube, he says they have done nothing wrong. And one then wonders, this level of confidence that there's nothing wrong that has been done perhaps speaks to a lacuna in law where there in fact probably is a gap, where the gentlemen know, we have a CFO here, these are senior officials, they would be familiar with the rules of employment. So the gentlemen probably know that in this instance there is no applicable law that prohibits them, after they have resigned, from working for a company that won a bid when they were still with the OCJ, because the only provisions that are there is that they may not do business with a service provider while still under the employ of the OCJ, and even restraint of trade doesn't apply to them because it just only prohibits you from working for a competitor. They didn't go to a competitor. They went out, resigned, to then offer a service to their former employer through a subcontract. So is there no lacuna in law here where they have just utilized their knowledge to get themselves this deal, but legally you might not be able to find them wanting?
The utilization of the inside information that they only got because they were involved on the buyer's side of the procurement of case lines is, if used as it has been used in this case, is notionally unfair and inequitable. And all the restraint of trade principles, the javelin principle that's mentioned in the article in the Sunday Times, and even the springboard principle, have as their basis the idea that business needs to be done in a fair and equitable fashion. Now, in South Africa, we've taken that a bit further when it comes to spending public money, and the money in this case is public money. And we've added three more criteria. The transparency, which obviously was not observed in this case, the cost effectiveness and the competitiveness. So between the five criteria of Section 217 of the Constitution and the powers of the Auditor General under the Public Finance Management Act, which actually puts flesh on the bones of the constitutional, the five constitutional principles. An investigation will reveal whether the threesome took advantage unfairly of their inside knowledge of what was going on and scored themselves a subcontract which they ought not, in fairness and in equity, to have had, or whether they did it in such a way that they have managed to satisfy the criteria for the spending of public money on goods and services.
Mr. Hoffman,
it needs an investigation. We don't know enough yet.
No, most certainly needs an investigation, particularly because it seems to be an age-old practice, this phenomena of javelin or springboarding. We've heard of it in the PIC, where it said board members decide to fund certain companies, and 5 minutes later they now work for the companies. Very problematic. Hopefully we will see an end to it now, with the OCJ looking to dig deeper, and perhaps there could be somewhat of a javelin clause, if you will. Mr. Hoffman, thank you very much for your time. That was Paul Hoffman, Director of Accountability Now. To this